I wish to talk today about the norms, principles, and practices to guide courts adjudicating climate litigation. All judges must decide cases according to the laws of their jurisdiction, without fear or favour, affection or ill will. Climate change cases are no different. In performing their duty, judges can have no agenda to ensure effective climate action is taken by governments or businesses. This does not mean, however, that judges cannot decide cases to ensure effective climate action if to do so is in accordance with the law. As was said in the US constitutional case of Marbury and Madison, it is emphatically the province and duty of the Judicial Department to say what the law is. Now, that task is easier stated than performed, especially with climate law. There are legitimate leeways of choice in finding the relevant law, interpreting it, and applying it to the facts found on the evidence. In making these choices, judges can be conscious of legislative purposes and climate considerations. These may enable a judge to find, interpret, and apply the law in ways that ensure effective climate action. Let me give two examples. The first concerns the influence of international climate law, such as the Paris Agreement. The Paris Agreement can influence domestic law and decision-making not only by the incorporation of the obligations under the Paris Agreement in domestic law, but also because of the norms that are embodied in the Paris Agreement. The Paris Agreement embodies norms that influence the courts in their task of finding, interpreting, and applying domestic laws. There are three norms. First, everyone must take action to mitigate climate change. Second, the temperature target to keep the increase in global average temperature to well below 2 degrees Celsius and preferably 1.5 degrees above pre-industrial levels. And third, the time target of net zero emissions in the second half of this century, now by 2050. These norms can influence domestic courts' adjudication of climate litigation. The norm that everyone must take action can influence courts in three ways. First, to reject the drop in the ocean argument. That is, a country's or a business's greenhouse gas emissions are so small relative to the total global emissions as not to be worth addressing. Second, to reject the market substitution and carbon leakage arguments. That is, if a source of emissions, such as a new coal mine, is not approved in one country, a substitute source will be approved in another country, resulting in the same or even greater greenhouse gas emissions. And third, to compare levels of ambition and action of different countries and businesses, such as emissions reduction targets and nationally determined contributions. Now, the influence of this norm can be seen in a number of cases, including the agenda litigation in the Netherlands, the Gloucester Resources case in New South Wales, and the Supreme Court of Canada's decision concerning the Greenhouse Gas Pollution Pricing Act. The norm of the temperature target can be used to calculate carbon budgets for the world or a country. Now, a carbon budget is the amount of carbon that can still be emitted so as not to exceed the temperature target. The norm of the time target can be used to provide a temporal reference point. Now, together, the temperature and time targets allow courts to assess the adequacy of the levels of ambition and action by governments and businesses and the consequences of proposed action, such as approval of carbon extraction or carbon emitting projects. The second example concerns climate consciousness in judicial decision-making. Climate consciousness refers to an awareness of the climate crisis, its causes and consequences, and the intersections between climate and legal issues. Climate consciousness can inform a court's choices in finding, interpreting, and applying the law. A recent example is the Land Environment Court's decision in bushfire survivors for Climate Action and Environment Protection Authority. The court interpreted the statutory duty on the EPA to develop environmental quality policies to ensure environment protection as extending to the protection of the environment from climate change. The statutory provision was interpreted to be always speaking, evolving in response to the ever-changing threats to the environment. One of the greatest current threats is climate change. The statutory duty has evolved to require policies to be developed to ensure environment protection from climate change. Now, these two examples illustrate how courts can perform their province and duty to say what the law is, so as to ensure effective climate action.